Thank you, Justice Kennedy, for agreeing to talk a little bit today about legal writing. Wanted to ask you, first of all, what are the qualities of a good prose style, a prose style that you admire?
I think they're probably ones you've heard mentioned often. It must be lucid, cogent, succinct, interesting, informative, convincing.
Why should it be interesting?
Because otherwise the reader's mind will wander. One of the great pieces of prose in certainly our legal heritage and really in literary history is the Constitution of the United States. I can read the Constitution of the United States cover to cover. Very few other people can. The Declaration of Independence you can read cover to cover. And it was designed to be read to the troops. Washington wanted and ordered it read to the troops in order to get them mad. He wanted them to be mad at George III. It was like an indictment of George III, and it has a dramatic progression to it. The more you read it, the madder you get at George III. The Constitution is a little bit different. The Constitution, I think, was not meant to be read in a single sitting. I've done it just for discipline to see if I could do it. My mind wanders, although my mind wanders into the right thing. And it should be interesting. Hamlet, I was rereading not long ago, and in one of the early scenes in the first act, the ghost is talking to Hamlet, and the ghost is describing his own murder. And the ghost says something to the effect, "And know, thy noble youth, that the serpent that did sting thy father now wears his crown," i.e. his uncle was the murderer. And I was thinking, a serpent in the garden? Does this sound biblical? But this is right out of the story of Adam and Eve. And was Eve, i.e. Gertrude, really behind this? So here I'm on one of the very early scenes, and my mind wanders. I have to stop. A half hour later, I begin reading the rest. That's really interesting. And the Constitution is like that. If I read it, I'll get through the first couple pages, and then I say, well, now I've never seen that before. Now this is really interesting. So that's good writing.
Now, you've read Hamlet many times, and this was the first time you noticed it. I know the line, but I've never noticed that similarity to the Adam and Eve story.
No, it's fascinating. And good writing, great writing, is one which captures the imagination and allows you, the reader, to become part of the text. Now, I think it would be presumptuous and arrogant to say that this is what we can do or should do with judicial opinions.
How did you come out, by the way, in adjudicating the murder of Polonius last week?
There was a trial where we had two of the world's finest forensic psychiatrists testifying in a trial in which Hamlet is on a trial for his criminal responsibility, not first-degree, second-degree murder, but just for his mental competence to be tried for the murder of Polonius. And the jury divided 6-6, which was wonderful. It was so wonderful everybody thought it was a fix, but it was not.
Outside law, what writers do you most admire?
Shakespeare, Dickens, because I read Dickens with my father. My father loved Dickens, and I would go with him when he tried cases, and I would read to him in the car. When we went to try cases when I was a little boy, he would take me out of school, and I would sit at the counsel table. So we would read Dickens. Trollope is wonderful because Trollope has all of the wit of Dickens, but he's much shorter. The problem with Dickens is that he's too long for the modern audience. Dickens was designed to be read in chapters each night by the fire over a long winter.
Because they came out in serial magazines.
Right. And so Dickens was designed to be long. Not sure. Trollope is much more concise. Hemingway, Faulkner. It just sounds like a literature great course. Solzhenitsyn, I think, required reading for law students is One Day in the Life of Ivan Denisovich. It just takes 1 day in the life of a prisoner. 1 day. And it's absolutely gripping. The writers talk about a sense of time, a sense of place, a sense of voice. This was a sense of place. You're in the gulag for 1 day, and it's absolutely fascinating. We think about voice is important in the law. What's an example? We had a case, I wrote it, Leesville Concrete versus Edmondson. The issue was whether or not in a civil case, two private parties, the government's not a party, whether it is lawful and constitutional to excuse a juror on account of the juror's race. It was a black juror who was excused. We'd had earlier cases where the court made the rule clear for criminal cases. Batson, B-A-T-S-O-N, is the leading case. But the question was whether or not this also applied in civil case where they're just two private parties. And at the end of the case, there was only a minute or so left. The lawyers made what basically a standing argument. What about the right of the juror? And it was a very beautiful statement to the effect that, may it please the court, this case is not just about my client, Mr. Edmondson, or my opposing counsel's client, the Leesville Concrete Company. It's about two jurors who are not in this courtroom and who are not parties to the suit. Their names were Willis Simpson and Wilton Coombs. I'll make up those names or something like that. They were excused from the jury without being asked any questions. We do not know if they could be fair. We could not know if they could be impartial because they were not asked any questions. We did not know their occupation. We did not know their education because they were being excused without being asked any questions. But those jurors, when they went into a United States District Courthouse that day, knew or thought that the right of service on a jury was as important as the right to vote. And for them, service on a jury was especially important because their fathers and their grandfathers and their mothers and their grandfathers could not have served. And we ask that this court keep the promise that was made in this courtroom in Brown versus Board of Education, the people are judged by the, not by the color of their skin, but the content of their character. And it was a very moving presentation, oral presentation. And I convinced my colleagues that this should be the voice for the case. It was the juror's voice that was the case. So voice is important. Got off. So time, place, voice.
Would lawyers do well to read more literature?
Yes, I tell my law clerks sometimes you can't write anything good because you've never read anything good, and that gets them interested. And some of the writers I've mentioned. Hemingway is one of my favorite because he's concise. There's a wonderful book about a woman who teaches writing and English to students in Kosovo. She goes with her husband who's in the Peace Corps of Kosovo. And she forgets to bring the book. So she's over there to teach English without a book, so she buys Hemingway, The Old Man and the Sea. Good choice because it's concise, short, good way to teach English. But also, the kids related to the old man because the old man was like the country down on its luck. And the young students related to the old man because they associated him with all the misfortune that had befallen the country. And so the book is about teaching Hemingway. And she, of course, later gets the Spencer Tracy movie. The kids all would come over to see her every night. And it's a beautiful book about teaching writing. It's called The Hemingway Book Club of Kosovo.
I don't know it, but I'll look it up. What is your earliest memory of writing?
Oddly enough, you'll think this is rather sad. It was when I was 10 or 12 years old and I marked up statutes because I was a page in the legislature. I wasn't happy in school, so they found me a job as a page boy, the only page boy in the California State Senate. And I had nothing to do, so I read bills, and I thought some of them were poorly written. It sounds a little nerdy, doesn't it? And then I worked in my father's law office, and I typed documents for him and copied. So when I was 12, 14 years old, I worked in my dad's law office. He was a solo practitioner. So and my father taught me how to write. He was a very good writer.
Was he maybe your main influence in developing as a writer?
Yes, I had a wonderful English teacher and history teacher in high school, and when I went to Stanford, I handed in a short story to Wallace Stegner, who was a great writer. And it reminded, when I handed Professor Stegner my story, I think my hands were shaking, just like when I handed in my first opinion around here to my colleagues. And I remember that event.
What about law school? Do you think law school tends to help people become better writers, or maybe sets them back a little bit?
I don't think it sets them back at all. I think it helps them because you think about the purpose of writing, and there's always a purpose in writing. Most young lawyers will have their first experience in sending a memo to another lawyer in the firm, or to draft a memo to the client. And you have to remember who your audience is, and the audience, if it's the lawyer in your firm, doesn't have a lot of time and is not interested in your displaying everything that you know. That lawyer has to have a quick answer and a clear answer. He wants to be convinced in a short period of time that you know what you're talking about because you have some authority, or that you don't and that it's an unclear question depending on how you come out. So you look at the audience. Now, with a legal opinion, we have different audiences. I write a case much differently if it's a railroad reorganization case than I do if it's a First Amendment case that the public is generally interested in. And you have various purposes in writing opinions, again, varying slightly because of the audience. You must convince the parties that you've understood their arguments. You must convince the attorneys that you've understood the law. And if it's a case of public importance, you have a different and much more difficult objective. You must command allegiance to your opinion. You must command allegiance to the judgment of the court. This is the common law tradition. It is quite different in this respect than the continental tradition. If you read a judgment of a European court in the civil law tradition, in its civil law jurisdiction, it would strike you as being rather uninteresting. It's digested. It is almost like a headnote in the West Digest. Whereas if you look at an opinion of the Supreme Court, say, in a case of public importance, it has a rhetorical, almost an emotive quality about it designed to instill this allegiance of which I speak. In the last 2 decades in Europe, we now have the European Court of Justice, the European Court of Human Rights, and other transnational courts. They are beginning to follow the case law system, the case law method that we're familiar with in the Anglo-American legal tradition. The only judges that knew that method were the Irish and the English and the Scottish judges on those courts. And I've had the great pleasure of meeting with those judges and talking about writing and talking about writing style in their opinions. And I've told them what I've just told you, that you have to look at the purpose for the opinion. The purpose for the opinion is to convince ultimately. The only authority our court has is the respect that's accorded its judgments. And that respect is based on what we write. And so writing is of immense importance.